of a partnership contract. General rule. A partnership may be constituted in any form, oral or written, except if an immovable property or real rights are contributed, a public instrument shall be necessary. If the partner contributed capital of 3,000 pesos or more in money or property, the contract must be in a public instrument and registered with the Securities of Exchange Commission. Failure to comply with the requirements does not actually prevent the formation of a partnership or affect its liability and that of the partners to third persons. If the partner contributed a movable property or real rights, the contract must be in a public instrument and an inventory of the said property must be made, signed by the parties, and attached to the public instrument. Failure to comply will render the partnership contract void. In a limited partnership, a certificate signed under oath by the partners and recorded with the Securities of Exchange Commission is required. Failure to comply will make the partnership a general partnership as to the third person, but continue to be limited partnership among the partners. Note that SEC registration is only for regulatory purposes. In determining whether a partnership exists, the following must be considered. Number 1. Persons who are not partners as to each other are not partners as to third persons, except when a person represents himself or consents to another representing him to anyone as a partner in an existing partnership or with one or more persons not actual partners. Number 2. Co-ownership or co-possession does not of itself establish a partnership. Whether such co-owners or co-possessors do or do not share any profits made by the use of the property. When the articles are kept secret among the members and wherein any one of the members may contract in his own name with third persons, they shall be governed by the rules on co-ownership. Number 3. The sharing of gross returns does not of itself establish a partnership. Whether or not the persons share them have a joint or common right or interest in any property from which the returns are derived. Number 4. The receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. Exception. No such inference shall be drawn in such profits were received in payment. A. As a dent by installment or otherwise. B. As the wages of an employee or rent to a landlord. C. As an annuity to a widow or representative of a deceased partner. D. As interest on a loan, though the amount of payments vary with the profits of the business. And lastly, as the consideration for the sale of a goodwill of a business or other property by installments or otherwise.